Delaware's transit service, moving forward.
What's up, everybody? I'm Grouchy Greg, co-founder of allhiphop.com, and I am hosting a very special edition of The Agenda today with a very special guest. Now, hip-hop music, since its emergence in the 1970s, has been a significant force in shaping technology and intellectual property. Originating in the Bronx, New York, it quickly evolved from a local subculture into a global phenomenon. This genre has influenced various aspects of technology, impacting the way music is produced across all genres. The advent of sampling in hip hop, which involves using snippets from existing recordings to create new compositions, revolutionized music production and led to extensive legal debates and developments in copyright law. As a result, hip-hop has played a pivotal role in redefining the boundaries of intellectual property while challenging traditional notions of authorship and ownership in the digital age. Once again, we're seeing hip-hop shape the narrative when it comes to the entertainment business and artificial intelligence. AI-generated songs mimicking the style of artists like Drake and The Weeknd have raised complex legal questions regarding copyright and intellectual property rights. This situation reflects the broader struggle of the law to keep pace with technology, especially in creative fields. And that brings us to our discussion today with U.S. Senator Chris Coons, chair of the Senate Judiciary Subcommittee on Intellectual Property, and a bill he is leading, the Nurture Originals, Foster Art, and Keep Entertainment Safe Acts, AKA the NOFAKESACT. Senator Coons, welcome to The Agenda. It's great to have you today.
Thank you. Great being on with you, Gretchen. Greg. That was an incredible introduction.
Oh, thank you. Thank you very much. So my first question to you today is, can you explain to me how you heard the Drake and Weeknd songs? You know, are you a big hip hop fan? How did this come across your
I got to
desk?
confess, my staff said, you got to listen to this. And I said, okay, what am I listening to? And they said, this sounds an awful lot like the real artist. It was hard on my sleeve, right? And you really can't tell the difference. So I will confess, yes, no, I was not just sitting there sampling Drake, but it was one of a couple of examples that folks who work with me brought in and said, here's an example of what AI is doing. In my line of work, which is politics, we just had the New Hampshire primary, and we got to see another sampling of what AI can do in terms of deep fakes, but let's keep it on all hip hop.
Right. So these types of AI-generated songs are not new. Yep. They've been floating around, to my knowledge, since about 2016, 2017. What about these two particular songs, caught your attention and made you, put this legislation into motion?
Well, they're getting better and better. As AI is accelerating, its ability to imitate our voice, our style, our bodies, our speaking, our images has caught the attention of everybody in the creative community, whether they're in music or in film, in production, in movies and documentaries of whatever type. So this is an emerging issue that is becoming more pressing. As the quality of the deep fakes has gotten better and better, you now really can't tell the difference. As we were just talking about, I grew up listening to George Carlin, watching some of his shows. They've just come out with a completely fake new set of George Carlin on stage, telling jokes. It's pretty hard to tell it's not him, but he's been dead for 15 years.
Right.
And if his estate didn't sign off on it, there's got to be some concern or some consequences. And if an artist can have their voice, their style, their song simply ripped off anytime, anywhere without any consequences, that weakens their rights as a creative, their control. But as you said in that insightful introduction, there's a long history in hip hop of having this practice of sampling and of taking and of piecing together, and it requires some agility on the part of legislators to get this right within the field of copyright and general intellectual property protections.
Got it. Now, speaking of legislation, This bill that you're proposing has bipartisan support.
Yes, it does.
As you know, I don't have to explain it to you, getting bipartisan support on anything in this particular Congress is not easy. What was it about this bill that led you to reach out across the aisle and, get general bipartisan support?
Well, Marsha Blackburn is a Republican senator from Tennessee. She's very close to the creative community in Nashville. This is really the center of country music in the United States. And so the recording artists, the studios there had reached out to her. I also reached out to her. Tom Tillis of North Carolina, conservative Republican, is my ranking member on this intellectual property subcommittee. He's been a great partner. So the four of us who have released this discussion draft of the bill, it's Senator Klobuchar, Senator Blackburn, Senator Tillis, and me. It's a good balance, 2 Democrats, 2 Republicans. We've done lots of meetings with the Motion Picture Association, SAG-AFTRA, the union that represents lots of creatives on Broadway and in the film industry, and the recording artists. And we're very close to what we think will be the final version of the bill.
Incredible. So, question, earlier this week we saw, 100,000 robocalls go out under Joe Biden's voice in New Hampshire using an AI-generated voice. And it's a really good example of how this technology could impact, our election coming up in 2024. My question is, someone like Joe Biden, who's a public figure, who under existing law gives up his rights to publicity because he's a public figure, how would someone like Joe Biden, benefit from this bill, if at all, under existing copyright law or, under existing copyright law? If you're a celebrity and you have your picture taken, you give up those rights to those types of images. How would this work with the voice?
Right. So there's more complex contours for public figures, but let's talk specifically about elections. There is a separate piece of legislation that Senator Klobuchar is leading with Josh Hawley of Missouri, Senator Hawley, where I'm also a co-sponsor, that specifically in the context of a federal election would require that any audio or video created using AI intended to influence the outcome of the election must say that it is generated using artificial intelligence. You essentially have to watermark it. If you're getting a robocall that sounds like Joe Biden saying, hey, Democrats, don't come out and vote today, which is what that call was, it would have to say, this audio recording was generated by artificial intelligence. Hi, this is Joe Biden. And it defeats the whole purpose because now it's no longer misleading. It immediately has you going, now hang on a minute, where did this come from? And it has penalties associated with it. We've seen this around the world. There was just a big election in Taiwan. The Chinese State Security Agency flooded Taiwan with 1,000 deepfake videos on social media. It didn't alter the outcome of the election, but in a recent election in a Central European country called Slovakia, a deepfake just like the one you were describing with Joe Biden's voice did change the outcome of the election. It's coming. So we need to pass legislation specifically to protect the vote. And folks, don't be fooled. If you're getting something through social media that just doesn't feel right or sound right, go check it. Go make sure that's real. But more broadly, this bill, the NOFAKESACT, would build on existing law called rights of publicity that are pretty well developed in New York and California, but that aren't national, and create what's called a private right of action, the right to sue. So if you are a well-known hip-hop artist, and you have years and millions of followers, and it's worth a lot of money, and someone else comes up and makes a fake, and they monetize it in a way that harms you, harms your reputation, harms your ability to make a living, you can sue them, and you can go after the sites that are propagating it to block it. That doesn't currently exist in federal law, and that'd be the main advantage of getting this into law.
Got it. Now, that brings me to another interesting question that I was thinking about as I studied this bill. Under the way current copyright and trademark laws work is, you send in your image, you send in your music, you send in your lyrics, and you receive your certificate, that you are the owner of these particular works. how would an individual actually physically protect their voice? Would they have to send in a copy of their voice? How does the voice get protected itself?
Great question, to which I don't have a great answer. One of the good things about this interview is you're making me study up on exactly how this law would be implemented in practice. But let's imagine I'm that artist. We all know that's not true, but let's imagine I'm that artist. I would send a notice to the platform or the creator that is taking advantage of my voice, and it'd be up to me to go into federal court and make the case. And it'd be a judge and jury that would be listening and deciding whether it is protected First Amendment speech, a parody of me, or a documentary that I appear in, or whether it is an attempt to literally steal or monetize the value of my performance and my capacity. This wouldn't just be for celebrities. It wouldn't just be for, chart-topping artists. This could also be true for average people. One of the things that has been, frankly, traumatizing teenagers is deep fakes that are, vulgar, that are pornographic.
Right.
Taking their voice or their image and then imposing it on things and then distributing it seems to be quite popular in middle school and high school these days in ways that are then very shaming and disrespectful to young people. You could also use this to prevent that, to prevent the unauthorized and inappropriate use of your image and your likeness and your voice. You'd have to show actual damages. But in cases, whether you're a professional hip hop artist or you're a well-known community leader, a civic leader who's being defamed in that way, this would give you a different route towards protecting your image and your likeness.
Got it. Now, under the bill that you're proposing, the person whose voice likeness is protected would have those rights 70 years after their death.
That's one of the things we're actively debating. Motion Picture Association wants that less time. We're debating over that. That allows the family, the estate of an artist to benefit from the lifetime work of that artist, essentially for a generation after their death.
So how does that align with existing copyright laws?
It aligns with existing copyright
70 years.
In the music field. Yeah.
Got it. So, when an individual, gets their voice protected in the NOFAKESACT, they have to have legal representation. Is that correct? In order to, benefit from this bill? Because my question is, the average person may not have legal protection, whereas someone who's as famous as Drake would,
Would.
How do you, how does the smaller person, take advantage of this, with, I guess I'm worried that, the average Joe, who you just, explained, may not have legal representation, even if their voice is being distributed in a way that is pornographic or, contrary to the way they want their voice used.
You make an excellent point. One of the things we've experimented with in the copyright field is essentially the copyright equivalent of small claims court, which a bill that I helped work on a number of years ago has created. So if you're a photographer and someone's taken your images off your website and is now selling things on Etsy that are like little jewelry boxes of your picture, let's say you make $10,000 a year off your photography. You're not going to go hire a lawyer for $10,000 to go sue this other person on Etsy. This small claims court within copyright allows you to file pro se, which means a lawyer word for without a lawyer.
Yep.
And the costs of proceeding are very small. The proceeding is fairly quick. It's not exactly Judge Judy, but it just like here in Delaware, someone tows your car without the authorization, you can go to small claims court yourself and pursue legal action against them without having to have a lawyer or the court costs and fees of going to superior court. That's just broadly across the United States. There's many communities and jurisdictions that have small claims courts. We should explore this. I don't have a great answer to whether or not proceeding without representation is possible. In federal court, pro se actions are possible, but not as successful.
Got it, got it. In my business, photography is a very thorny issue. We have to have licenses.
Yep.
If we don't have licenses, we're quite often sued.
Yep.
And this has created a whole class of lawyer who specializes in sending takedown notices and forcing a settlement. And it's become a big business for a lot of these lawyers. Do you envision, small claims courts being overrun with some of this?
Look, that's one of the concerns that's being debated. The First Amendment creates protections for the use of images and a voice for certain purposes, for parody, for historical documentaries, as I mentioned earlier. And one of the boundaries that we're debating, between SAG-AFTRA and the MPAA and the RIAA and others, is exactly how broad will the carve-outs be for First Amendment use. If they are broader, there will be less legal action, and the takedown notices will be relatively easily dismissed. If they're narrower, then there's more legal protection for creatives, but it also means there may be more legal activity in the field.
Right. Now, that brings me to this question. Under the current Digital Millennium Copyright Act, the DMCA, platforms have 7 days to take down any infringing work. Right. And under the NOFAKESACT Act, platforms could be held liable for this infringement, which right now is not the case. So you're talking about going up against Meta, Google, Spotify, Apple. This could really damage their bottom line legally if this bill goes through. Do you envision what kind of pushback or anti-lobbying efforts might come from this? Because that's a really big change from how the internet has worked for the past 30 years.
Yes. Under DMCA, the notice and takedown regime is just not working for a lot of the creative community because that period is too long. And they are capable, these platforms, of receiving notice and performing takedown actions almost instantaneously, very quickly. So that is an ongoing discussion about what the notice and takedown regime, what an injunctive relief regime would look like in the DMCA context. Senator Tillis and I are also working on modifying the DMCA and improving the ability, for example, the movie studios. So many movies are pirated at this point that it's amazing anyone still pays to go to the movies.
Right.
That we are losing hundreds of billions of dollars a year of revenue to crews and actors and studios because of that. So we do need to work out exactly what the notice and takedown system would look like under the NOFAKESACT. That is an active negotiation. But that's part of how you get relief. And the idea that there's no liability whatsoever for platforms for what's posted, for conduct, that's Section 230. That's also being actively debated, what the new contours of that exemption from all liability will look like.
Got it. Now, within this bill, there's a carve out for news, parody, public affairs. How do you envision this not creating a loophole for bad actors? Because as we saw with the New Hampshire incident with Joe Biden, that obviously would be illegal under this bill. But let's just say they did it as parody on YouTube and presented it as parody.
So the First Amendment is a fundamental. The free speech rights that are embedded in the First Amendment to our Constitution are foundational to our democracy. So even if we put in this law that it covers everything regardless, if you're sued and what you've been doing is engaging in parody, you've got an immediate defense. So in crafting the legislation, we thought we might as well call out the boundaries of what we understand to be judicially created First Amendment jurisprudence. Congress can't create a legal liability that violates the First Amendment, and that's the purview of the courts to say what the scope of the First Amendment is. So yes, this is going to create an avenue for bad actors to misuse parody, to do things that they shouldn't otherwise be able to do, but that's the First Amendment. It allows people to say and do things that we may not want them to say and do. But that's part of what makes America free, and part of what makes America great is that people have the right to stand on the street corner and say, Chris Coons is a jerk, without consequence. And
Better not say that about our senator.
But the First Amendment is foundational, and so we're trying to make sure that the safe harbor carve-outs that are in this statute reflect the current state of jurisprudence in the First Amendment. But it moves as courts make decisions.
Got it. Now, this is a really big deal for for artists, actors, anybody who is looking to commercially exploit their voice. What kind of feedback have you gotten from the entertainment industry in particular? Because I could envision a situation where artists say, hey, look, this is a brand new bargaining chip that I have that I may not want to give up to the record label or the movie studio. I can envision this becoming a very sticky negotiating point. What's the feedback been like?
This was an active issue in the strike that was just recently concluded between the studios and SAG-AFTRA. The question of AI and its future and its role. Look, we've seen films recently where AI was used to either finish a film where a certain actor passed away before the film was completed, or to allow them to appear in the film, either older or younger than they actually are. AI has been used in studios for years now. In recordings, it helps some recorded artists sound just a little bit better than they actually do if you're in the studio using AI. Maybe I could be a great singer using AI assistance. But this was an issue that we engaged with right off the bat. SAG-AFTRA has endorsed this legislation. The studios are actively engaged in discussion with us. That strike is settled, so the AI provisions that are going to cover all work in the film industry are well known, and this law would be aligned with much of their direction. The recording artists and the performing artists who are represented by unions have been at the table and negotiating in this. So too have the studios. So our hope is to reach consensus before we move this for a markup in the committee. But look, the whole part of being in Congress is compromise, which means not everybody gets everything they want. You got to move towards the middle and craft something that's actually going to work. As you mentioned at the outset, Congress has really struggled to effectively legislate in the digital age, whether it was email or websites or surfing or digital. And this is an attempt by the senators that I'm working with to be current, to be relevant, to recognize that this is an active issue. There are many actors who are saying, is my career going to be over? I've done one film and now the studio owns me and my voice and my image forever, and they're just going to create a new me and have me say and do whatever they want me to. That future is coming. One of the things that was in that negotiation that surprised me was there are people who make a living off of being in the background, being in crowd scenes, being, that's mostly going to be AI-generated people in the future.
Yeah.
There are lots of people who make a living dubbing. So being the guy in Italian who dubs every English movie, that's now mostly going to be done by AI.
Got it.
And so there are active debates about what does this mean for the future of performers, actors, creatives. My hope is that we will, by giving this strong publicity right, give more tools, more defense to those who earn a living from creating amazing music, great experiences, beautiful movies, and important moments for our lives.
So this bill obviously covers the United States. But as you know, these industries are global industries. Have you thought about what impact this could have internationally and how you may go about enforcing this in territories that are not covered by U.S. jurisdiction?
There are regular debates about the extraterritorial reach of American legislation in all sorts of different areas, from antitrust to criminal law to banking. Intellectual property is no less active. The studios and the actors, as you mentioned, are global performers, and their product and work is globally distributed. We have trade agreements with most of the countries in the world, and they increasingly have digital provisions. They have intellectual property provisions embedded in them. And the World Intellectual Property Organization is the UN-affiliated agency that helps harmonize IP law globally. It would be my hope that this would be seen as an example of how to strike the balance between free speech, individual rights, and the industry, and that a similar law would be adopted by the European Union, the UK, Canada, some of our partner countries like Japan or Korea, and it would gradually become a global standard. Obviously, the PRC, China, has a fundamentally different view of individual rights and free speech. The Great Wall of China of the 21st century is a firewall. The internet and studios and performance and censorship are quite different on the other side of that firewall. So my hope is that this would end up being a global standard for nations that have free markets and free speech. Hip hop has been a global phenomenon, and my hope is that this kind of a framework for protecting both the industry and the creatives who drive the industry would be adopted globally.
Incredible. So as we wrap up, what is next for the No Fakes Act?
Well, we're hoping to get to final text, and as I've been saying, that requires some give on the parts of all the different parties, and then we're hoping to get it marked up by the Senate Judiciary Committee, and then it'd be ready for action on the floor. Getting it through the House is a whole other thing. They have a different Judiciary Committee with a different majority and a different set of interests, but the impact of AI on the creative community is something that is a pressing concern across Congress as well as across the aisle. So I'm hopeful that we can make real progress, get it to the floor of the Senate this year, but I'm going to have to keep working at it to make that happen.
So Senator Coons, how can the hip hop community get behind this act? You know, I jokingly invited you to the Grammys with me to help socialize it, but I was, also being a bit serious as well. How can the community, get behind you to support this act?
Well, speaking up, speaking out, posting in support of it, sending in letters or testimony or recordings in support of it. I'll remind you that Senator Schumer is the leader of the Senate Democratic Caucus. He's the one who sets the agenda for what gets a vote on the floor, and he is from Brooklyn.
Yeah, he's a big supporter of hip hop culture as well.
Yep.
So for my final question,
Yes.
I created a perfect replica of my voice for viewers of the agenda to get an idea of how far this technology has come over even the last 12 months.
Wow.
And so the AI Grouchy Greg is going to ask Senator Coons the final question, and we're going to wrap up the show.
Cool. Thank you.
Hello, Senator Coons. It is truly a pleasure to be a part of this interview. Wow. So here's my question. We have seen companies like OpenAI, Stable Diffusion, and others use commercially copyrighted data sets to train their large language models. These companies have become billion-dollar juggernauts using other people's copyrighted material, and outside of the larger publications, no one has been compensated. As the chair of the Senate Judiciary Subcommittee on Intellectual Property, do you plan to go any further in offering other businesses deeper protections?
That's an incredible deep fake. I mean, that sounds just like you, and asked a really good question, as you have. Yes, the question of scraping copyrighted material to train large language models is a very active question. Sam Altman, who's the creator of OpenAI, ChatGPT may be known to your viewers. I just met with him a week ago. He came and testified in front of the broader committee. Senator Schumer and a bipartisan group of 4 senators have convened probably a dozen different roundtables on AI, where we've had all of the leading edge creators and practitioners in the AI space and the platforms and representatives of all the different industries and unions and advocacy groups that are concerned about it. I do think we need to protect copyright, whether it's journalists whose work at the New York Times has been scraped and stolen, but it's copyrighted material, or it's photographers or songwriters. How large language models are trained is not currently transparent. And having some transparency and some accountability ultimately is going to be critical for having an AI-powered world that protects individual property rights. And one of our challenges is that AI is moving, is progressing in some ways faster than the rate of our ability to regulate it. So we've had this dozen series of roundtables. Once we get past the border security bill that we're working on right now, I expect that Leader Schumer is going to ask for committees to come forward I'm hoping my No Fakes Act is ready for action at that point. But I also think we need something in copyright that helps address this theft, this use of content to train LLMs.
Senator Coons, thank you for appearing on the agenda. It's been an incredible discussion.
Thank you.
Thank you for all your efforts in working to protect creators in the music and entertainment business.
Thank you. Great being on with you.